We're going to discuss about the budget, 3.5 trillion budget bill, what's in for us on the employment-based immigration. We're going to touch the topic. We're going to discuss about the new vaccination requirements, COVID vaccination requirements. When we file the adjustment of status, what are the do's and don'ts, and there's a lot of rumors flying around that. We'll also discuss about the continued delays of the adjustment of status that have been filed, and also I-140 delays, particularly the Texas Service Center, and the impact on how people are getting affected on it, and is there any solution that we can find on getting these delays reduced to an extent that are manageable. Emily, we saw this employment bill, we saw the 3.5 trillion budget bill. This is the biggest budget bill ever passed by any time, by any government, by US or anywhere else. But what's in it for the employment-based? Do you see that there are any provisions that are there for the employment-based? I mean, it has a lot of other things in there, border protection and all those things. Is there a chance, and what are the possibilities for getting any of the employment-based? They have seriously discussed about the dreamers on that. Seems that definitely is going to be in there. What else is expected in there?
Yeah, and this is going through the reconciliation process right now in both the House and the Senate. So we don't have the actual language of any of the provisions that they will use to carry out this policy of immigration reform through the budget process. As of right now, it seems to be geared towards TPS and DACA and farm workers. And there's a provision, they refer to just qualified individuals.
Legal immigrants.
Right. And so I think that there is potential that this would include age-out kids. I think there's potential that this could include recapturing of wasted green cards from prior years. Maybe there's a chance of eliminating the 7% cap.
Per country limit.
Is this something where they're just, along with handing out green cards to TPS and DACA, they're just going to say, oh, if you have an approved I-140, you'll get your green card too? I don't see that happening. I definitely would push for it. I think that is, one of the difficulties with employment-based immigration is there's not really an advocacy group that's pushing for these things. It's all individual-based. There aren't employers that are really standing up for people to try to move this across the finish line. And for the Dreamers, I mean, they've been advocating strongly for decades. And they're finally now to the point where maybe they could get something passed. They've gotten to this point multiple times before over the last decades. So we're at a very precarious point, and we need to be, reasonable about what can be included there, but there's certainly no harm in advocating that there be provisions for the employment-based.
Is there any draft that we can prepare for them to give it to them, Emily?
Yeah, I think that right now is the time to reach out to your senators and your congressmen, your representatives, with a request to not forget about employment-based applicants, and we'll be providing templates for
We're going to provide the template. I want you to log into RN Law Group news section. By tomorrow, day after tomorrow, we're going to provide the sample letters that you need to write. You can use, if you want, to write to the congressman. Emily, you're telling that there's a lot of lobby going on with the Dreamers. These are the people children who came undocumentedly or became undocumented later on, though. Why is that there is so much push there? Why is that there is a consensus in the Congress that everything should be done there? What about these people who have been legally in this country, maintaining their status, and why can't they do the provisions for that? There's no mention of this thing. Not the Congress people don't mention anything about it.
I think part of it is there is no lawful option for Dreamers. There's specific, the way the statute and the regulations are set up right now, they don't have any option. Whereas employment-based, there is a system. We just don't like the system. It takes way too long. The 7% cap is discriminatory. The backlogs, it should not take someone until they retire to receive a green card, or maybe even not even get it by then. But there is a system. I think that's the difference, is there is a solution. It's not a great solution. And there's just not people advocating.
I think so. The second aspect, what you said, is the correct thing, is that we people are not advocating these things. We people don't write letters to the congressmen. We don't voice it. As you pointed out, the employers are not interested that much in pursuing the efforts of these things. The employees are careless. They don't care much about it. Who is going to write the letter? And we have written so many letters, nothing happened. Look at what the dreamers are. I mean, they got their employment authorization before Obama went out. I mean, that was a very good thing. They fought much more. I remember that the senator from Nevada, he cried on the floor of the Senate for pursuing that effort. He couldn't achieve it when he was a Senate chief, though. But it came later on in 2000, before the Obama administration went out. That was in 2016, I guess. So I believe that it is the advocacy efforts of people contacting the congressman, having them writing the letters. So please be watchful on these things, and we will put a draft by day after tomorrow on rnlawgroup.com. Please watch for it, and we may put a amended link on it in the provisions that we're making. Please write a letter, and don't forget that we already put a letter there where having the USCIS accountable for the green card applications that they're wasting. If you have not written the letter, I don't know what to say. I would say that you are one of those Nazi kind of people who hate Indians and who hate race. You're just racist. That's what I feel. So you better write the letter that is going to take the that's going to help us. At least, we got an opportunity after so long, after we got 120,000 green cards. And if we miss it, it may take up to 10, 12 years for us to get it. And if we don't keep on pursuing this one, they will do the same thing next year. So that's 270,000 green cards just will go in waste instead of just giving it to the people. So please write the letter to the congressman, watch it on RN Law Group, because this is an important time. Emily, I mean, when would this bill be passed, though?
Yeah, this is something that's got to happen in the month of September. Last I was aware of, they're trying to get the reconciliation bill together around September 15th so that this can go through by the end of the fiscal year, since October 1st starts our new fiscal year.
On the COVID vaccination, Emily, a lot of people are under the assumption that, hey, you need to have the COVID vaccinations that need to be listed in the medicals that they are filing right now. But when I look into it, it's actually any medicals that have been signed on or after October 1st, is that right, Emily?
Right. Yeah. So if you're getting your medical exam done right now, it does not require the COVID vaccine. For those that get the medical done after October 1st, when the medical is actually issued after October 1st by the civil surgeon, that's when they will have to specify that the COVID vaccine is met.
Is the provision of the 693 is not revised yet, is that right, Emily?
I don't believe so.
Yeah, and if by any chance the form is not revised, though, I definitely want your doctor, if the doctor is signing the medicals after October 1st, on or after October 1st, please have them put a letter there, have an evidence that you have taken the COVID vaccine in there. Probably make a copy of the card, the COVID vaccine card that you already been provided from the medical facility where you took it. Have a copy of it saying that vaccination taken. Both or one depends on Johnson & Johnson. Please have it mentioned it so that you don't have any problem with the medicals. So, Emily, on the Texas Service Center become a nightmare right now for the 485 and I-140. They took 4 months to issue the receipt notices, which at one point of time, especially before, it took 4 months to get the 485 approval. They took 4 months to issue the 485 receipt notices. Any solution that you have?
Yes.
And for them to get the green card, and now the I-140's premium processing they're rejecting too.
Right, yeah, and we have started receiving transfer notices of some cases from Texas to California. Hopefully that's a good sign, but of course that does add some extra processing time in, as it's got to actually get transferred over there and get assigned to somebody. We are seriously looking into litigation as a way to resolve this issue. You know, we've got these I-140s, the downgrades are filed only at the Texas Service Center. We have no choice of where those go when it's filed with the 485. And it took them so long to issue receipts. The processing time is more than 10 months for a simple downgrade. It's the exact same thing that they've already approved. Literally, it's just a different box checked. Why do they need to re-adjudicate the entire I-140 petition? Can't they just change the category? Why do they need to grab the labor certification from the old file and move it to the new, or pull the copy from the Labor Department? They have all of these policies with there's no legal requirement for any of them. So that we are definitely looking into litigation on that aspect for these delays in the I-140s. The only way to get an I-140 approval out of Texas right now is premium processing. And those that are lucky enough to get accepted, yeah, that's great, but they keep rejecting the premium, saying they don't have the labor certification. Why do you need it? I sent you a copy. It makes no sense. So we're definitely...
It was already provided to them when the original I-140 has been filed. So why do they need them for the application that they have it? When we file the Freedom of Information, it takes only 3 weeks for the USCIS to give the same labor certification. Why can't they get it by themselves, though, which is there? So it definitely doesn't make sense. There are people that are saying, oh, it is because Srikant from Bellam from YouTube is saying, hey, it's because of the Afghan refugee thing. That's the reason they have been delayed. No, they will have one other. There's a COVID excuse. There is this excuse. There's that excuse. I have seen previous administration. All they need to do is that, hey, all the service center directors are fired 6 months from now if you don't bring the 485 processing time to 4 months. Guess what will happen though? Then nothing will happen. Everything will become current. It happened. It happened. When Bush administration came in, he said, reduce the time in 6 months. These guys won't reduce it. They won't listen to the president. You know how these bureaucrats are. I have seen so many presidents. It's okay. They will keep on telling on. They didn't. Guess what Bush administration did? All district directors are fired 6 months from now. Guess what happened, Emily, in the 6 months? The processing time from 4.5 months came to 3 months, less than 2.5 months. Yeah, that can be done. There are excuses these administrations making. As Emily is pointing out, they are re-adjudicating the I-140 applications unnecessarily. They can give a lot of preference on the 485 application. They don't have to approve the EAD's advance parole. Just adjudicate the 485. Don't take much time on the EAD in advance parole. You adjudicate the 485. You automatically deny without even looking into the EAD application, without looking in advance parole application. You can deny the H1B for that extension. You can deny the H4. You can deny the H4 EAD once you approve the 485 application. These things can be done. There are a lot of different steps we have suggested USCIS in the previous letter that we advocated to write to the congressmen. They have given importance to the 485, but not enough. There is another solution. What we suggested last week is that they can grant you the green card and take it back next year so that it will be counted again. Please, everybody, write that letter to the congressman, because we have seen the action. We've also seen the reports that are coming on from the USCIS. There is a lot of pressure on them from the Congress to not waste these green cards, because what the Congress is telling is that, hey, why do we need to increase the green cards when these stupid fellows are just wasting the green cards when their genuine opportunity was there to use it? So it's a good question that they're asking. So you may want to put a lot of pressure from the congressman to adjudicate these applications, because that's true. 120,000 extra green cards right now, 150,000 green cards. Please have these things adjudicated. Put a pressure on the Congress, put a pressure on the USCIS. The draft letter is provided in the link. Amit is asking this question. Yes, more than 1 million GCs has been wasted from USCIS. That is right. A good number of them are coming on the employment-based immigration because they can't do the work what they're supposed to, what they're being paid for. That definitely can be added to this budget bill, the budget bill that we have. There are a lot of suggestions that we would have in our draft letter that will be coming in the next 2 to 3 days. So please watch for it. You know, you have to be advocating yourself, guys. Nobody else is going to do for it. We're going to just give the opportunity and the know-how, how, where, what to contact, but you guys have to get this thing done. We will prepare it. Yeah, you're right. You're right there that they did wasted 1 million green cards from 1992 to right now, Amit, from YouTube.
Nick has a question about remote work. He's on H-1B and wants to know if he can move to another state and work remotely from home for the same company, even if the company does not have an office in that new location. Yes, absolutely, no problem with that. It's not necessary for the company to have an office there if you'll be working remotely from home, but they will need to file an amended H-1B petition with the new LCA prior to you actually making that move.
Can USCIS approve 2 full-time H-1Bs, one main employment and the second as a concurrent, one being the remote, one non-remote? That question comes from Shailender. Yes, they can. 2 full-time employment, 2 full-times are allowed. I do work 70 to 80 hours. I mean, that's what I do. Even right now at this age, so nothing wrong. You guys should work much harder. Pay more taxes for us. That's good for us. Good for the economy, good for you.
Pratusha says, am I correct in understanding that people that have a visitor visa can come to the U.S. after quarantining in a third country for 14 days? Yes, so if you are subject to a travel ban based on the COVID situation in the country where you are, if you are able to travel to another country that is not a banned country, wait there for 14 days, you can then enter the U.S. This is assuming that you have a valid visa already.
Naveen has this question. His priority date is May 2010, but received a visa regression letter from Kansas City field office. How do you want to proceed on this issue? From Houston, got multiple people, same issues. That definitely need to be raised. You need to go to the congressman. That is the best hope. Lawyers are unable to get in touch with the USCIS officials right now. The other option would be probably you need to definitely consider suing the USCIS. Look at you dumb guys, what are you doing? How is the priority date May 2010 retrogressed? I mean, what are you speaking about? It's definitely worth suing it. On this particular aspect, you have a good chance of winning. I mean, I can't believe that if you file a lawsuit, you send a notice to the USCIS, I'm expecting them to respond instead of responding to the court. You may want to consider suing the USCIS. If you want to contact Stephen Brown in our office, is the best guy. You can go to the appointment section there, and that guy is the best guy in our office for you to contact for suing USCIS on this aspect.
Mahenbal from YouTube wants to know, is there any update on H4 EAD premium processing? Can we expect it by the end of next month? I can say that it appears USCIS is working on this. There were some recent liaison notes from a meeting between AILA, the American Immigration Lawyers Association, and USCIS, and they did mention in one of their answers to a question, kind of in passing, but they made it sound like they're working on getting the premium processing going for H4 EAD for both the I539 and the 765. Can we expect it by the end of next month? That's up in the air. USCIS has a lot going on right now. I'm not going to hold my breath on that. They're generally not on time when it comes to regulatory actions, but we'll definitely keep our fingers crossed.
Vincent Dave from YouTube has this question. Thank you, Rahul and Emily, for working so hard on preventing the wastage of the green cards. Why can't your law firm file a mandamus and temporary injunction, request a judge to preserve the visa numbers, just like our competing law firm? Our competing law firm did a good job on that. We don't say that it's nothing wrong, but we have tried previously on the 485 delays. We haven't been successful. The courts were reluctant in taking the delays on the 485. It was tried on the diversity visas. It was tried on a number of other occasions. In fact, our business, we have partners with Jonathan Waston, whom we partner in suing the USCIS many times, but because of that, particular courts are reluctant in taking up the adjustment of status delays, and that's where the problem is. There are not many successful cases in it. In fact, believe me, we had a Zoom session with a lawyer from Seattle on that issue, pressing. We're trying to go to different law firms and see what if they can come with some creative ideas. In fact, we may form a consortium of immigration lawyers that will try to look into another way of getting the delays addressed by the USCIS. One of the things what we are looking at is especially the difference between the Texas Service Center and other service centers could be one of the reasonable things that we can think of. Any other things that you can think of, Emily, and getting it, court accepting our cases on this one?
Yeah, there are issues. We're trying to figure out where we can file these lawsuits. You have to meet certain requirements regarding that, and what is the likely response from USCIS attorneys going to be. They tend to want to try to delay as much as possible. They don't want to provide discovery. So there's a lot of hurdles in any kind of litigation. With USCIS right now, they like to blame COVID and say, oh, there's nothing we can do, we're doing the best we can. So we need to really come up with the best strategy for that, and we are actively working on that. We want to be able to provide a solution. I know it's tough when your hands are tied and then you feel like there's just nothing you can do, you have no hope. We are working on that. We're trying to get something together, and we'll keep you posted on it.
Within our own office, there's a lot of tension on it. Me and Emily want to push for the litigation, but our litigation department is like, if they don't see a reasonable way to succeed in that, what's the purpose of litigation? Which makes sense, of course. So we're trying to pursue different methods, but we will update you if we find something that we feel is reasonable and we should be able to get a good result. That's what we're trying to do. And then, Stephen Brown in our office, he's very hardworking person in our office, and he's definitely trying to different methods, but at the same time, he's definitely doesn't want to file a court litigation unless he seems that he's going to be successful, or a possibility of successful. He doesn't want to proceed with it, and that's where we have. That's where we are in our office right now. But we'll keep updating you on that. Vincent, thank you for your suggestion.
Ashish from YouTube received the medical RFE for his spouse and daughter, but not for himself. What should I do now? We are seeing this. We're not really sure if it's an issue.
He got it for his wife and daughter?
Right, but no RFE for him, and he's the main applicant.
Is it medical?
Yeah.
Okay.
So we would, I would suggest, yes, go ahead and provide your medical as well in response to those RFEs. But when you get your medical done, see if the doctor will give you a second original copy that you can keep with you. It'll be valid for 1 year, correct?
2 years.
2 years. So that if you still get the RFE, you've already got the medical and you can immediately submit that again.
We're also noticing, Emily, that there are people who are receiving biometrics. One thing is that children under 14 will not receive any biometrics for the 485 application. If somebody receives, it's most probably for the EAD, not for the 485 application though. So if the children under 14 don't receive it, it's okay. Now you may have noticed for the H4 though, they have received the biometrics. That is right, for H4 they will, but for the adjustment of status, they're not eligible for receiving any biometrics. It's okay if your family received, the child doesn't receive it. Under 14, don't worry about it, you're fine. Now, if one of the family adult, anybody more than 14 years old have received, the other people have not received, my suggestion is that take the entire family there. Anybody above 14, if let's say, for example, there is a 16-year-old kid, wife and husband, if the 16-year-old kid and the wife got it, the husband did not get it, all three of you guys go and try your luck there. There are some times that they have taken, there are some times they have not taken. Please try to go. It may work, it may not work, but if I were you, I will try taking the whole family there.
Govinda wants to know, can an NIE letter help to get an emergency appointment? So yes, the consulates, if you actually need a visa stamp, they're only taking emergency appointments right now. All regular appointments are being scheduled for next spring. So you have to first schedule the first available appointment, which will be sometime in 2022. And then you can go in and request an emergency appointment. And for that, yes, you do need to demonstrate the emergency, but also that you are likely qualified for an NIE. So you'll need that letter for both emergency request as well as when you go to the actual appointment if you get the emergency request to prove that you qualify for the NIE.
Ganesh is asking, can you form an advocacy group and can you make us contact the congressman? What we can do, Ganesh, is that we can draft the letter and provide it for you. There are a lot of WhatsApp groups, Telegram groups, a lot of different groups though. What my suggestion is to have these groups, press it on, and provide the sample letters to the people to write it though. As such, to form an advocacy group or any lobbying group, it's a very expensive deal and there are a lot of rules and regulations that we have to follow. If we have to form a formal group collecting any money, it's a big problem, a big expenditure. All I can suggest you is that we will provide the draft letter. I mean, right now, social media has it's the best thing that can be done. So you can circulate these things in the social media. We are going to provide it to you in 1 or 2 days. You circulate it, you among the group, I will do it, have all of your friends do it, and have everybody write a letter. Particularly what I would be more interested, Ganesh, is that a lot of the people who have climbed up the ladder, who got their green cards long time ago, they forgot that they came to the ladder and they don't write letters though. They would like you to come to their temples. They would like you to go to their the language associations that we have, Tamil, Telugu, Hindi, a lot of different language associations that there are. You may want to put a pressure on them to say, hey, we as the people of immigrants, if you guys don't all put a booth there and make sure that every entrance person will go through your booth and will have to sign a letter, and you can put some computers and all those things where they can write a letter, and that will be the way to enter into that language association, let's say Telugu association, let's say Tamil association. In the entrance, they have to write a letter to enter into it. You may lobby that one. These are the things that I can suggest what you can do. But as such, for us though, to just leave our office and create an advocacy group, that may not be, our families are dependent on this one. We definitely want you guys to take the initiative from your side, do as much as possible, and see if there is an advocacy comes on. You see that there are a lot of these NASCOM and other groups that have a lot of funding available from them. You guys don't have that funding available for you. So why don't we take a look at the dreamers though? I mean, there is no money, there is no advocacy. It's these people pounding on the doors of the churches that they go to, pounding on the doors of the organizations, the political organizations that they go to. That's the effort that they did it from the ground up. I would suggest that you do that. We provide the letters, you do that, you do the effort. And you, not just you, but everybody like you who's affected by it should do that effort.
Raul from YouTube wants to know, can my employer get the recruitment process done before receiving the prevailing wage determination for perm? Is that illegal? It is not illegal. It is possible, but there are some risks with that, especially right now because the prevailing wage is taking so long to receive. You have to make sure that your ads, the recruitment efforts, they're only valid for a maximum of 180 days. And the prevailing wage is taking 150 days. If there's any delay in getting the prevailing wage, your ads might expire and you may have to start that process again, which is very expensive, especially the newspaper ads these days are quite costly to the employer. So I generally right now am not recommending you to start the ads as soon as the prevailing wage is submitted. It would be best to wait at least 3 months. Better yet, wait till the prevailing wage comes in. Is that mandatory? No, but at least give it 3 months so that when the wage comes in, you've got time before your ads actually expire to give you time to file.
Rahul Katie from Facebook asks this question. I am working for the same employer. Do you still advise to do the premium processing after the downgrade? Yes, Rahul, I would strongly recommend, because one thing is that you may lose the job. You may want to change the job. There are a lot of things that can go. Unless you have some teenage kid, I would definitely do the downgrading. I would convert into premium processing. Rajesh from YouTube asks this question: can a person be unemployed and GCEAD? Is there a limit of number of days that they can be employed? Rajesh, if you're contemplating, if you are the main applicant, I would definitely want you to check with your lawyer. There are some creative ways of avoiding the unemployment. If you are the dependent GCEAD, you're under no obligation to be working, that's fine. When I got my GCEAD, for a period of time, I was a dependent EAD. I was not working, so that was perfectly okay. There is no, but if it's a main applicant, you definitely need to check with your lawyer though.
S2 Sai says, my I-140 EB2 with a priority date of 2014 is from company A, but I moved to company B in 2021. They suggested to file PERM and I-140 and EB3. Can we use the company A EB2 priority date when filing the company B I-140 and EB3? Yes, you can. As long as that I-140 from the EB2 was approved, you get to keep that priority date for any future I-140 you file, whether it's an EB1, EB2, or EB3.
Question with regards to the I-130 was filed in October 2019 by, from California with my green card file. When can I expect to receive the green card? I'm assuming that you filed the 485 application also though. Typically the time period is about 2 years, but we have noticed that it's a little bit longer right now. For you to get the green card. You will be interviewed before you'll be given a green card, because it's a family immigration, especially marriage thing. They will interview you before you get the green card.
Bhavesh has an EB3 approved with the 2013 priority date. He also changed companies last year and is working on the new PERM with the new company. Meanwhile, his previous company filed for bankruptcy, and he wants to know if there's any provision where the current company can skip PERM and take over the process from where it was left. Unfortunately, no. That I-140 is no longer valid because the company is out of business, but you can keep the priority date, but you do have to go through the PERM process and new I-140 with the new company.
Ramakrishna Rajagopalan has a very good question. Can I write a letter to Congressman even though I did not file the 485 application? My priority date is not current, or is it only that those people who have filed the 485 who are in the process? Ramakrishna, if you are waiting for the priority date to be current, you should write a letter even though you did not file. The reason that you need these people to get the green card faster is that if you're waiting for the green card, unless they get the green card first, your turn will not come. Your turn will not come. You will have to keep on extending the H1s, H4s, EADs. Every time you go outside the country, you have to get the stamping. Look, there's a question from Shanaz Daridia from Facebook. She's asking the question, can I do a passive income of H1B on YouTube and blogging? No, you cannot. So these are the kind of difficulties, Ramakrishna, people will face if they are waiting for the green card though. So it is for all the people, those people who have filed for the green card application, those people who are intending to file for the green card, those people who have come up the ladder, like me, Rahul Reddy. I came up the ladder, I got the green card. I want the people to not be discriminated. I don't want the green cards to be wasted. People like me, everybody should write a letter. There's nothing wrong in writing a letter. And it's just wasting the green card comparatively, just giving the green cards, who have been waiting for decades. Anybody can write a letter. And an American person who has never immigrated, who has never been in the process, also can write a letter. They just need to modify a little bit on that. The letter that Emily has drafted in the RN Law Group, that they just need to modify a little bit. But anybody can write a letter. That's nothing wrong. And the links were being provided to whom to write the letters, to the congressman, to the USCIS Ombudsman. The links were being provided there.
Demetri from Facebook has an I539 H4 Extension application that was filed online in July. And for online applications, USCIS does not send the physical I-797 receipt notice. They're suggesting you use the online notice. She wants to know, in this situation, can I use that online H4 receipt notice to file the 485 application if the priority date becomes current? Yes, absolutely. We had a ton of people in that exact situation last October that we filed the 485 even though the H4 extension was still pending because the processing times were so long. Of course, with an H4 extension, 90% of the time, probably 99% of the time, we expect that it's going to be approved because the H-1B has already been approved, and you are married, you're just waiting for them to process due to long processing time. So assuming that H-4 does eventually get approved, then the 485 can be processed as normal. If the H-4 has expired less than 6 months from the day you file the 485, then technically you don't even need that extension to file the 485. There's a special rule about 180 days, Section 245K, for employment-based immigration applicants that includes the spouses of employment-based applicants.
A lot of questions with regards to the prediction of the priority date. It does definitely looks like in the month of October, they may not move the priority dates much. For the EB3, and EB2, we may see some movement in the month of October. If we are successful in our efforts, though, then definitely we're expecting a lot of movement in November. But if the 100,000 green cards will be wasted, or 120,000, who knows, will be wasted, though, we may not have good movement coming in the next year. So it is important for us that these green cards will not be wasted for the dates to move. For sure, not much movement in EB3 in October. There may be some movement in October for EB2. We may expect a good movement in November if things fall in the line as what we're expecting.
Barath wants to know if a person who's in H-1B can convert to H-4 as a spouse if they lost their job and then later convert back to H-1B when you get a job. It is possible, but there's some practical, technical difficulty with it. The main thing is the H-4 processing time. So yes, if you lose your job while you're on H-1B and your I-94 is valid for at least 60 days, you do have a 60-day grace period, and during that 60-day grace period, if you're not able to file an H-1B transfer, you can file a change of status to H-4 to become a dependent on your spouse's H-1B. The difficulty is when you're ready to convert back to H-1B, USCIS is going to want that H-4 approval notice. Well, H-4s are taking 12 to 15 and a half months at some of the service centers right now. So you may end up having to get that H-1B approval notice for consular processing, exiting and coming back in order to get back in H-1B status. That is easier to do if you already have the H-1B stamp. Otherwise, you're stuck with a stamping problem, with the consulates not operating, and possible COVID restrictions. So there are some difficulties there.
Question from Parshuram Francis is that his priority date is April 2017 under EB2. Can he take the priority date and file an EB3 application with company B? If you are contemplating and using the labor certification of company A to file an I-140 under company B's for EB3, Parshuram, you cannot do that. You can only do it with the same company that has the labor certification. However, if you want company B to start the labor certification all over, and then your previous I-140 with company A was not being withdrawn within 180 days after it's been approved, you can, based on the new labor certification filed by the company B, you can file the I-140 under EB3.
Tilodama wants to know, do you have any updates regarding employment-based consular processing at the U.S. consulate in Mumbai? How can we know how many they are processing each month? Well, I don't have those numbers. I don't know if anyone does, but what I can tell you is the Department of State has a 4-tiered system for immigrant visa processing at the consulates. Employment-based is at the bottom of the totem pole. So they're really not processing employment-based immigrant visas. They're focusing on the more urgent issues, the Afghan issues. They are focused on age-out cases. Those are in the tier 1, tier 2, but employment-based is the very bottom of the list.
Emily, questions are coming with regards to the remote marriages now. There is a county in Utah that allows people from here to get married in India. How viable they are? Can we use those marriage certificates to file the I-130 applications? Can we use those marriage certificates to file for the H4s and other things?
Yeah, based on our research into that question, I don't think that marriage is going to be considered valid for purposes of a dependent visa like an H4, or for family immigration, or for filing an adjustment of status, or consular processing of as a follow to join type of situation.
Yeah, this question came out just because they issue a marriage certificate. It may be valid for other purposes though. But when it comes to the immigration, they go with a different rule. So you have to get those things, you have to get the proper marriage physically done by the husband and wife. Otherwise, they won't let you. They won't let you get the H4 or the immigrant visa based on the marriage.
Harsha wants to know, can we file 2 I-140s with an approved perm application? Yes, you can. If your priority date, it might be current in EB2 or EB3, you can absolutely use that same perm and file 2 I-140s, one in EB2 and one in EB3 at the same time.
Any idea, a couple is asking from YouTube, any idea how much time you are seeing for the employment-based interview results are taking? Typically it takes about 1 week to 2 weeks though. That's a normal time that it takes. But is it that we are seeing all the cases within 2 weeks, or sometimes do we see a lot more time than 2 weeks? Sometimes we do a lot more times than 2 weeks.
Akila says, my I-140 for EB1 has been pending from February 2021 in the Nebraska Service Center. Do you see any possibility of processing times improving for this category? No, they've been a good year to process for very long, prior to COVID. So that's not really a COVID thing, it just COVID made it worse. But February 2021 is generally not considered that long of a processing time for EB1.
Question that came on with regards to, once I get the green card, can I in turn apply for my parents' the green card? No, you cannot apply for your parents' green card until you are a U.S. citizen. Only U.S. citizens can apply for the parents' green card. Green card holders cannot.
Sai wants to know, if an H4 is pending and the H1B changes the employer, will the H4 pending application be affected? Does the new employer need to file an H4 again with the H1B? So technically, it should not be impacted. The H4 can be approved and continue to process as long as the H1B is maintaining status, regardless of which employer the H1B is maintaining status with. However, from time to time, especially in the case where the old employer withdraws the approved H1B after you have left, we have seen USCIS automatically deny the H4 months later, saying, well, you're no longer in H1B status, so we can't approve the H4 extension. That is completely wrong what they're doing, but they don't give you a chance. They're not sending a request for evidence asking for proof that you have a new H1B in place. They're just denying it. I've filed motions to reopen on this exact issue, and those have been successful, but it's an extra hurdle, a lot of long processing time that you have to go through. So I would recommend file the H4 again with your H1B transfer to be on the safe side.
Amit has this question. V. Lakshmi from YouTube has this question. I-485 and I-485J has been transferred from NBC to Texas Muscat. Any thoughts on the priority date is May 16, 2010. Why would they transfer from NBC to Texas? Texas is the worst place to transfer. But unfortunately, there's not much that can be done by you. We don't know why they transfer from one place to another place, and sometimes within 2 days they transfer it again, or really they are messed up completely. But there's not much you or I can do about it right now.
Garima wants to know, can we submit the same I-693, which we got last October, but could not submit until now due to a delay? It depends. If the doctor signed that 693 before you filed your 485, then that 693 is only valid for 60 days and it would be expired now. If you got the I-693 signed after you filed, then it is actually valid for 2 years and you should be able to submit it now.
Kata has this question: what are the chances that the filing dates will be accepted in the October? And he's also checking with regards to the EB2 to EB3 spillover. It doesn't look that the chances are great for EB2 to EB3 spillover. One of the things that what we are noticing, Mr. Kata, is that the amount of green cards that were approved in EB2 is much, much higher than EB3, Emily. The ones that we filed in October. The ones that got adjudicated in recently, though. So we may not expect some spillover, but anyway, we are expecting a lot of wastage this year, though. The amount that is allocated for EB3, these stupid guys have not even adjudicating those number of EB3 applications, though. So we may see a lot of wastage rather than spilling over from EB2 to EB3. So that's where we stand at. Yeah, there is a good chance that the filing dates will be accepted in the month of October.
Yeah, I think in the last 5 years, they've generally every year been accepted in October, except for the very first year.
Yeah.
Barath wants to know, do we have to go through the H-1B lottery again if we convert from H-1B to H-4 and then want to go back to H-1B? No, you don't. Once you've been counted as long as you either were in H-1B status in the U.S. at some point, or if it was consular processing, you got the visa stamp. As long as you've not exceeded or used up your 6-year limit, you can switch back to H-1B at any time in the future to get that remaining portion of the 6-year limit.
The question that comes from Sadiq Mirza: the company is not filing from EB2 to EB3 downgrade. Is there anything can we apply from outside? Is there any implications? No, you cannot apply from outside. You have to go through your company only. Unfortunately, you don't have much choices there. Question from Katta Sumant with regard, I think so you already answered this, right, Emily? With regards to H4 need to be filed again?
Different person asked a similar question, but
Yeah.
if the H4 is already approved and the E80 is already approved, no, you don't need to, but you may want to, so you all have the same end date.
Yeah, a lot of questions are coming with regards to, in the daily conference call that we have, is that if the H4 and EAD is pending and you move to a different company, and if you move to a different company, though, I strongly recommend that you file the H4 and D80 again. The reason is that what we have noticed is when the previous company withdraws the H1B application because you left the company, they may automatically deny the H4 and D80. This happens only 10% of the time, not all the time. But to be precautionary, though, I would strongly recommend if you change the company, if the H4 and D80 is pending, do file the H4 and D80 again.
Harish wants to know, he submitted his medical in response to an RFE back in July, and is there any general timeline on when I can expect the response? So prior to USCIS really ramping up these RFEs, I would say that a lot of times we were seeing the approval within a month, but now that they've sent so many RFEs and everybody's responding back quickly, they may be a little bit overwhelmed right now, and it may take longer for them to actually get to your case and see that you've submitted the medical. So I don't have a good timeline right now based on what is happening currently.
Questions with regards to the medical things. Do we need to submit even if the RFE is not there? We do recommend that you submit. We have made a link for you to submit the medicals there, for you to help yourself out in there to submit the medicals by yourself. You can follow the link. Now, for a while, we said that we are receiving a lot of RFEs on medicals, don't submit. We told that about from past 2 to 3 weeks, but we have seen a reduction in the RFEs. We don't see that many RFEs that are coming in the past 4 or 5 days. So yeah, I do recommend that you submit the medicals, and we have provided there at the link where you can do it by yourself. The link is provided there.
Jyoti wants to know, the priority date is not mentioned on the 485 receipt. Is it an issue? No, that's very common. Most of the time they don't include the priority date on the receipt notice for the 485. Similarly, if you filed an I-140 downgrade, or a case where you're actually retaining the old priority date, the I-140 receipt notice generally does not have the old priority date on it. It will either have the new priority date of the new perm or no date at all. That's not a problem at all. That will be assigned at the time of approval.
Manish Agarwal has filed an Interfile FYI request to see if the Interfile medicals have reached. That's a creative option. Please let us know the results, what come out, Manish. We will be watching you closely on that. Manish, there's a different Manish who has a question, is that right? After getting the green card, do we need to carry the supporting documents for the port of entry of the international travel beside foreign passport and USA green card? No, you don't need to carry anything. USA, the green card and your foreign passport is enough. If by any chance you carry, don't show it to them, because sometimes they get confused. What is this guy trying to tell me? Sometimes you give them extra documents, they're completely confused, they don't understand it. They'll tell you, well, let me take you to the secondary, and then we will see what we can do about you. So just give them the green card and passport, that's good enough for them.
Rajesha wants to know, can we apply for the I-765 more than 6 months before it's expiring based on a pending I-539 application? Although the guidance from USCIS and their instructions say, no, you need to wait and send it only after the 180-day mark, we have done that many times. We've seen maybe 1 or 2 cases where there was some pushback from USCIS saying, hey, you submitted this more than 6 months in advance. So there's no guarantees, but as of this moment, there's no harm in doing it.
A question that came out from AKS. My priority date is July 2013, filed I-140 downgrade and accepted in premium processing. Should I wait for the I-140 approval or file the 485 application? Since you already got the acceptance of the premium processing though, I will wait for the result to come in, because it may be only 1 week or 2 weeks. I will in advance prepare the 485 application, make it ready, but I will not file it, I will wait. But I probably would have filed 485 before, if, because you never know premium processing is, but since premium processing is accepted, I will wait until the results comes in.
Kodamasu wants to know, what are the chances of documented dreamers being included in the budget bill? So of all the different possible employment-based provisions that could go in that bill, I think this one, my opinion, has the best chance of getting included. And again, I think it's because there really isn't an option for them. That's the same reason why the dreamers, undocumented dreamers, are likely to be included, whereas employment-based waiting in the backlog is not, because you have a system. We just don't like this system. But for those kids that are aging out, once you age out, you don't have any other option. Yeah, you can go the F1 route and then get in the exact same line that your parents were in, but you don't have an option to get the green card along with your family when family unity is one of the top priorities of our U.S. immigration system. So I do feel like of all the employment-based provisions, that one has the best chance of being included.
Question from NK557, and there's an answer from another person called Krishna Achur. Can I request a congressman for I-140? expedite request. And Rao, he's saying, Krishna Rajar, there's no point. My Congressman Rao, Congressman Khanna just gives a standard response. I'm tired. Yeah, especially when you are trying to request the expedited request. These Congress people don't have much authority there. There's a liaison there. They send a letter to them, and the Congress liaison there in the USCIS office will send a standard letter, and they will respond to you in the standard thing. There is not much that can be done. That's the reason why we want you to write the policy letters, not just the case assistant, but the policy letters, though. Especially the policy letter that is attached there, not wasting the green card, though. It may not, it may not be profitable for you alone, but it may, as a community-wise, it definitely works better. We strongly suggest that you write those kind of letters more.
Sandeep has a 485 pending for more than 180 days. The I-140 downgrade was approved only 3 months ago. He wants to know, can we change the employer and file the 485J? Can my previous employer withdraw my I-140 since it's only been approved 3 months ago? So yes, so once you have your I-140 approved and your 485 has been pending for 180 days, you do qualify for AC-21. If you have the EAD, you can use that to switch to a new employer as long as the job offer is in the same or similar occupational category and the new employer would submit the Supplement J form. Now, yes, the old employer can withdraw your approved I-140, but it does not impact your 485 because you have the 485 pending for 180 days. There is a 6-month rule related to I-140 approvals, but that's for people who have not filed the 485. In that situation, those people should wait 180 days before changing employers so that that I-140 priority date can be retained. They can keep using that I-140 for H-1B extensions and keep using that I-140 for H4 and EAD extensions.
Ralla Paslini has this question. His EB2 is 9/30/2011. Downgrade to EB2 or wait for the priority date to become current. I would file a 485 right now, and rather than waiting for it to be current, though, because you never know how the things will move in. I would prepare the 485 and I-140 and wait for September 15th, and if the date becomes current in October, then I will file a straight application. Otherwise, when the priority date doesn't come in, I'm going to file the downgrade application, though. It's there right now. Why not file it right now? That's the main theory that I have with people. A lot of people, initially, they said that, you cannot file the downgrade application. They said that. They've been proven to be wrong. I mean, we did file the 485 downgrade application, no problem. They said, no, they will never accept the premium processing. No, they do accept the premium processing. There are some cases that get rejected, though. There's some truth in it. But you should try to do the premium processing if you can. Sumit has this question: why Indian origin politicians don't help their people in the new administration? Good question. We do have a president that comes from an immigrant family from India. Sorry, not the president, the vice president that comes from there. We do have a lot of politicians that come in. We have congressmen. But you believe me, when you go to them, though, they don't even understand the immigration process as much. These people either, like, for example, the vice president, she didn't went through the immigration process by herself. It's the mother and dad. They forget the ladders for which their family came out. We need to mention it to them. We need to write them letters. We need to explain it to them. And one way is by ourselves doing. I also want, believe me, when I go to, my age people that got green card long time ago, they have no clue what's going on with you guys. Believe me, they don't understand. They have no clue. Oh, I thought people are going to get the green card in 1 to 3 years. I said, no. So they have no clue. They don't understand. They climbed up the ladder. They never look back. Mostly it will happen with you guys too, guys. I mean, believe me, it will happen with you guys too. But what I want you is that if you explain the people who have come up the ladder, Hey, look, buddy, you got the green card in 2 years, 3 years. Look at me, I'm here for 10 years. I'm not getting it because of that reason. These people are funding the politician. These people have much more voice than you do have. If they write letters to the congressman, they do respond much faster than you do. So you need to put a pressure on the temples that we go with the association, and also on the language associations that we go to. You need to put a lot of pressure on them. When I tell them, they just ignore. But I see a lot of students. I see a lot of the H1B coming. I mean, they come in when the movie star comes in. They flock around and all those things. But they don't pressurize the people, the elderly Indian community people. They don't pressurize them. So I want you guys to put a lot of pressure on them.
Well, I think we are out of time for today. Thank you so much for joining us. Please remember to subscribe to our YouTube channel and our Facebook page, whichever one you're watching on, so you'll get updates on whenever we're live again. And you can subscribe to our newsletter at rnlawgroup.com.
Thank you guys for tuning in.